thank you all for being here today. I'm excited to have Julia Kellison joining us for this workshop on consumer debt issues. So Jennifer Quiroz, I'm the Executive Director of the Financial Empowerment Network. And I would like to start today by actually doing a introduction. So we're going to do some introductions and announcements. If folks have announcements or updates from your organization, I'll invite you to share those with us in just a moment. Then we'll have Julia, and there will be some time for question and answer. She's got Q&A available. So hopefully you all brought all of your questions. Now, I realize that 90 minutes is not a lot of time to learn everything there is to know about consumer debt and collections and garnishments. And so part of this will be a jumping off point for 2022 to really hear from all of you what you're interested in learning more about. And then we'll be coordinating further workshops next year that'll go more in depth on particular topics. So thank you for being here today and engaging with us on this sort of broader topic, and then we'll be going deeper next year. So just a quick introduction of Julia. She has been a partner of the Financial Empowerment Network for a long, long time. I remember when I was teaching financial education, attending one of her workshops about medical debt myself and being like, what? I didn't know any of this. So a long history in educating all of us about a lot of these debt issues. So thank you, Julia. She's a consumer attorney at Northwest Justice Project's Seattle office, and her practice includes challenging debt collection abuses involving medical debt, garnishments, and predatory lending in student loans and auto sales. She's on the executive committee of the Washington State Bar Association's Antitrust, Consumer Protection, and Unfair Business Practice section, and received her JD from Temple University School of Law. Thank you, Julia, for joining us today.
Thanks so much for having me, and I'm really excited to have a discussion, really, and as we go through the slides and the topics, it'll be way more interesting if you guys stop me or put in the chat. Actually, I'm really not super adept at watching the chat and the PowerPoint. And Jennifer, do you have the PowerPoint? Awesome. Okay, yay. So feel free to jump in with any questions as we go. And you guys have clearly tons of experience in these areas. And I'm very interested to hear what you and your clients are seeing and have more of a discussion. So I'd say use the chat. And Jennifer, if you can watch the chat, that would be awesome. So I've been at NJP for about 23 years, which is crazy to say. And consumer law has really always been a passion of mine. And I love talking about these topics. I'm also happy to consult with folks in the future. And I can provide my email address, and Jennifer has it, or phone number. Really interested to hear from you all about issues your clients and consumers, you know, what they're facing. So to dive in, this is really pretty overview-y, the overview of the debt collection and the life of a debt and lawsuit. So default generally occur. Oh, and one other thing, there's 99% of this information is contained in the publications on WashingtonLawHelp.org. It's a site written for non-attorneys with Know Your Rights publications from lots of different organizations. I use it all the time. It's got landlord, tenant, family law, consumer benefits. It's really a fabulous resource. So, and I will highlight on these slides the publications that this information comes from. They've got sample letters, sample pleadings. It's really, really great. So I encourage you to use it, and don't feel like most of this information comes from them anyway. So, and the information is really only good up to today in the presentation. So with many of the sites that I'll be talking about, it's important to check back in the future. So you're looking at updated information after today. So in general, in terms of the life of a debt, someone defaults on a debt generally after the first missed payment. And that creditor has 6 years, it's called the statute of limitations, to sue the debtor for most consumer debts. And if you make a payment within that 6-year period, that statute of limitations, that 6-year time period restarts, and the creditor can get another 6 years. It extends the life of the debt another 6 years and gives them another 6 years, that time frame before it's too late to sue on it. If you make a payment after that first 6-year period has expired, a payment after the 6-year period will not restart the statute of limitations. And that's a recent-ish change to our state law, which is really helpful. We saw creditors trying to incentivize people to make a payment after this, the statute of limitations had expired and restart the debt that way. And our state legislature changed that. So the publication that's helpful on this particular information is called Debtors' Rights Dealing with Collection Agencies. We have a really strong law in Washington called the Collection Agency Act. It's at RCW 19.16, and it lists a lot of requirements that debt collectors have to abide by. They're required to contact you in writing, and the notice has to have certain information. They first contact you by phone. You can ask them to contact you in writing instead. And you have the right to demand that collectors don't contact you at all. The first written notice from a debt collector has to have some required information, include who they are, who the original creditor is, and the account they're collecting on. And it's got to also include your rights to dispute or get verification of the debt. If you don't know what you're looking at, you don't remember it, you have the right to get more information. For medical debt, there's been some good recent changes that for debt collectors collecting on medical debt, they have to provide certain information and more specific information regarding that debt. And that too, that information is in Debtors' Rights Dealing with Collection Agencies, that publication that's listed there. State and federal laws prohibit harassment by debt collectors, prohibit them from saying false or misleading statements or unfair practices. And if you believe a collection agency has unreasonably harassed or misled you, it's important to contact an attorney. And I'll list legal resources further in the presentation. And next slide, please. So when someone is served with a lawsuit, and served meaning someone hands them a lawsuit or hands a co-resident of theirs a lawsuit at their residence, there's 20 days to respond to the lawsuit, or the plaintiff, which is a word for the party suing you. If you don't respond within 20 days, the plaintiff can enter a default judgment without notifying you. Really important to contact an attorney immediately after being served with legal papers. And there are a couple ways, as outlined in the How Do I Answer a Lawsuit for Debt Collection publication, how you can respond. It's important to, no matter what, to enter a notice of appearance, which tells the court you're there, you want to be contacted, you want to be made aware of going on, here's my address. And if you have defenses, it's important to file an answer. And there's a really great checklist answer and a autofill form for folks to use in the How Do I Answer a Lawsuit for Debt Collection, which lists a lot of common defenses. So again, I use that publication all the time, and my clients use that publication a lot. If your only income is from exempt benefits, like SSI, SSDI, Social Security, and we'll go through some of those in a little bit, it's really important to let the plaintiff know that. Hey, you're not going to get anything I've got no income or assets that can be taken to pay this debt. In some instances, that can stop the lawsuit. In that, how do I answer a lawsuit for debt collection? There is a link to a publication called, to a form called a Declaration of Exempt Income and Assets. It's a checklist form, and there's an explanation of how to fill that out depending on what your exempt source of income is. So say you don't have any defenses, you owe the debt, it's within the six-year period, it's the right amount that's being sued for, the debt collector can get a judgment, and that judgment's entered for consumer debt. It's going to be entered with a post-judgment interest rate at 9%. That got lowered a few years ago from 12%. Not as low as we wanted it to go, but 9 is better than 12. And they have a right to try to start collecting on it. If they don't know where you bank or where you work, which are the two biggest sources of money that they can attach to pay themselves back on their judgment, they may summon you back to something called supplemental proceedings. It's really important, if you get a notice for a hearing called supplemental proceedings, it's really important to show up if you're summoned to court, because if you don't show up, a bench warrant can issue for your arrest, which is pretty scary. It's rare, but it can happen. So you cannot show up to your trial on the original debt or your hearing on the original debt, but after judgment, if you get summoned to this, it's really important to attend this proceeding. And what they do is they'll put you under oath, and you have to answer questions about where you bank, where you work. They have a right to know, and that's what happens at that hearing. Now, a few years ago, we found that folks, particularly in Central Washington, were being jailed for medical debt. And of course, many of those folks, presumably low income, and had a right to apply for charity care, had defenses to that debt, but were not showing up at this supplemental proceeding, this post-judgment hearing. A bench warrant was issuing, and some people were jailed, which is just awful. And a coalition of consumer groups brought this to the legislature's attention, and that is no longer allowed. Debt collectors cannot request bench warrants at supplemental proceedings if people don't show up when the debt is medical debt. And if you hear about anyone, even if it's not medical debt, being jailed for consumer debt, and it's being jailed for consumer debt, but it's really about failing to appear at this hearing, please contact me. I would really like to know if that's occurring on any other type of debt, including medical debt. All right, next slide, please.
Julia, there's a question in the chat about how long someone would be held for.
So, it's essentially until they, it depends on the court, and these are district courts that we're dealing with. It depends on the court, but it may be until they can promise to get to the next supplemental proceeding or pay bail. So again, it's rare. We don't hear about it a lot, but we definitely want to hear about it. If you hear about it. And again, it's failing to show up to this post-judgment hearing. There are other ways debt collectors can get the information. They don't have to schedule this hearing called supplemental proceedings. They can send paperwork by mail to say, to obviate the need to bring you back to court. They can mail paperwork to say, tell us where you bank and where you work, and provide us this information. And that's another way they can get the information. But again, really important, if they schedule a supplemental proceedings, really important to show up. And again, happy to answer questions if you or your clients face this, and please contact me. All right, so for bank account garnishment, after a judgment's entered, a bank account, a creditor can garnish a bank account or wages. Judgments are valid for 10 years in Washington and renewable for another 10 if they follow the right process of renewal. So that's 20 years of a debt accruing at 9% interest. That's a long time. Some other states have moved to shorten that judgment period because that debt can double in a jiffy, and on and on and on. For a bank account garnishment, you don't get notice ahead of time because we'd all race to the bank and empty our bank account. There are some automatically protected benefits, Social Security benefits, Social Security disability benefits, supplemental security income, and VA benefits are automatically protected in a bank account from garnishment for consumer debt. And consumer debt is just what you think: credit cards, medical bills, debts owed to landlords, phone bills, that kind of thing. So the big exception to the rule that these federal benefits are automatically protected in a bank account is if you bank to an institution at which you owe money. It doesn't matter what is in the bank account. Per the account holder agreement, they can reach in and pay themselves back no matter the type of income that's in the account. So really important to open a new bank account, if necessary, redirect those automatically protected benefits because they are vulnerable and they don't have to sue you to pay themselves back if you owe money to that bank, be it a loan, a credit card, whatever. It's vulnerable. I also talk to my clients a lot about not commingling non-exempt income with exempt income. So if you have, say, SSDI being direct deposited into a bank account, you get a check from your Aunt Susie, do not deposit the check from Aunt Susie into that direct deposit account. Cash it, use it, but don't put it in that the account containing the exempt benefit because it could render that money non-exempt. And you really want to, if you have two exempt benefits, so SSI and SSDI going to the same account, that should be fine. If the bank gets a writ of garnishment from the debt collector after the judgment is entered, they can look in the account and see both, the only money coming into this account by direct deposit is coming from these exempt sources. Also, one thing I caution folks about is, all right, you have that direct deposit SSDI account. Some people transfer the money into a savings account and then pay bills out of that. You don't want to do that because that money sitting in the savings account could be rendered non-exempt also. It now just looks like cash in an account. It doesn't show the direct deposit. So you want to have that direct deposit money go into the account and be spent out of the account to keep its exempt character. So debt collectors cannot take this money. All of this information is in Money That Cannot Be Taken to Pay a Debt, a really helpful publication. I probably send that out and look at it 5 times a week. It's really great. It gets updated. And the amounts, it's just important to refer to because it gets updated as the state minimum wages go up or there are changes that the state legislature makes to the laws that that these topics are based on. All right, ready for the next slide. Thanks, Jennifer. So then there's money that's protected in a bank account, but not automatically so. And then you have to take some action if your account is frozen to claim that money back through something called an exemption claim form. And it's in that publication called at the bottom of this slide called How to Claim Personal Property Exemptions. So if the judgment is based on a private student loan judgment, $2,500 is exempt in a bank account. $2,000 for consumer debt judgments is protected in a bank account. And wonderfully, as of July 25th of this year, $1,000 cash in a bank account is now automatically protected in a bank account from collection of consumer debt. The exemption is still $2,000, but the first $1,000 is automatically protected, and you'd have to use an exemption claim form to get back the other $2,000. But it's a big help. It's not. We'd love for the entire $2,000 amount to be protected, but it was a compromise in a legislature that brought about the $1,000. The one that, it's an enormous protection for our clients. Their account cannot be fully wiped out in the collection of a consumer debt. And they can still claim $1,000 more through this process if everything above the $1,000 is frozen by the bank. It's really important to do right away, and I'm happy to, if you want to reach out or contact a Northwest Justice Project attorney if someone's account is frozen. We want to get that process started right away to unfreeze that money. For all other debts, $500 is exempt. Unemployment, both federal and state, is exempt from debt collection. Not automatically, so you have to claim it. TANF benefits, earned income tax credit, the additional child tax credit is exempt. Again, not automatically so really important to act quickly using that pub or calling an attorney to help file that exemption claim form. Federal student loan money, child support money you receive, and most pensions are exempt, but not automatically so. All right, I'm ready for the next.
Julia, there's another question in the chat. How likely is the exemption claim for the second $1,000? How likely is it to be approved?
It should be approved because that's the law. You have a right to claim that additional $1,000 because the exemption is $2,000. It's just that $1,000 of it is automatic, and the next $1,000 is what you have to claim through this process.
And how long does that process usually take for folks to get their money back?
It can take a couple weeks. And there's a time frame within which you have to claim it. It can be 21 or 28 days, and that I won't go into the details of that today, but some good detail is in the publication. But you have 21 to 28 days, depending on a certain date. I'm not going to go into it, but to file that exemption claim form to get the money you're entitled to. Any of these types of benefits or income, but not a lot of people know about it. So, it'd be really helpful to have at least the full $2,000 automatically exempt, but consumer advocates weren't able to get that. But $1,000 is a big help, and we really want to just get the word out about this process. If your account's frozen, act right away, contact an advocate, and let's get some help and get your access to the money back right away. And we know how destabilizing it can be, as we all do. We all know that, for even a day, let alone a couple weeks, to not have access to the full amount in your bank account. So we really want people to claim money that's rightfully theirs and not the debt collectors.
Great. And I also put in the chat, I already created a folder to save this PowerPoint into as soon as we're done today. So you can grab the links from the slides. I just can't save it while I'm also running it. So as soon as we're done today, I'll upload it there so folks will have access to these links.
Great. Thank you, Jennifer. So as we talked about, we just sort of covered this. Really important to act quickly, get that exemption claim form in. Most pensions are exempt from garnishment even after you receive them, but some aren't. So if you can, get that pension check mailed directly to you versus depositing it into a bank account. But anyway, that's just a tip from that publication. And the next slide, please. So wage garnishment, that's the other way a creditor can get access to your money to pay itself back on a judgment. So the good news of the wage garnishment, you get notice ahead of time. You generally get notice ahead of time. So, which could be a good time to reach out. You can call Northwest Justice Project or me. Wages have been protected more fully in the last, the protections have increased, I should say, in the last several years. Our state has moved to protect more of people's income, which is great. Again, all of this information is in What Money Can Be Taken to Pay a Debt publication. If you earn less than any of these amounts, none of your wages can be garnished to pay back a consumer judgment. So those values are there. These are the values that change because, as you can see, it's based on the state minimum hourly wage. And this is the values listed on this slide are for consumer judgments. And that wage is indexed. So the hourly wage, the minimum wage is indexed. So this amount is going to change every year. And if you earn more than these amounts listed here, you can still keep the greater of 35 times the state minimum hourly wage or 80% of your net pay, whichever is more. All right, I'm ready for the next slide. Again, all of this information is in this publication. For private student loan judgments, if you earn less than the amounts below it, none of your wages can be garnished, and these values are higher. The legislature took action in the student loan debt crisis to increase the amount protected. This is the highest protection. It's 50 times the highest minimum hourly wage in the state, which is not just the state minimum wage, the highest one in the state, which is currently $16.69 an hour. And if you earn more than these amounts, you can still keep 50 times the highest minimum hourly wage in the state, or 85% of your net pay, whichever is more. For other judgments, not consumer, not private student loan judgments, the amount you can see there is what's protected from a wage garnishment. And the way wage garnishment happens is the creditor will send something called a writ to the employer. Say you let them know by filling out the paperwork, or they know where you work. They send a writ of garnishment to your employer to say, we have this judgment. We want you to withhold what we're entitled to. And then the employer fills out this worksheet telling the creditor and you and the court how much can be taken out of your paycheck. It's really important to check your employer's work and make sure the right amount, they're not taking any more than they're entitled to from your paycheck. And there are ways, and I'm happy to talk to folks and consult if, a wage garnishment can take a chunk of your income, which for our clients, that can be a big hit. And there are ways and other things you can try to negotiate in lieu of a wage garnishment if there's no defense to the debt and you can't sustain this ongoing wage garnishment. And one of the options is bankruptcy, but another option is something called a wage assignment. But happy to talk to folks about that if your clients are facing that issue. All right, I'm ready for the next slide. So a big driver, I coordinate a weekly remote debt clinic. We've been remote since the beginning of the pandemic. And medical debt continues to be a big topic, a big problem we see at our debt clinic. Unfortunately, it's too well kept a secret, in spite of all the efforts by the legislature to increase the notice requirements by hospitals and debt collectors of charity care. Charity care is an enormously, excuse me, an enormously powerful right, a really wonderful law that can provide free care to low-income people and people that qualify. So, and it goes higher than you think for a family of 4, making up to almost $80,000 at some hospitals that go up to 300% of the poverty level for 100% charity care coverage. It's more money than you think, so we just encourage people, apply. Don't count yourself out, certainly, from charity care eligibility. The charity care laws are in that revised Code of Washington provision and the Washington Administrative Code. They're actually very readable. And the thrust of the charity care laws is about access, low barrier. You know, if you need help applying in your language, if you have a disability, you need help, you need extension of time. It's all about allowing low-income people access to this enormously powerful right. So if someone comes to you with a hospital debt, you can find the hospital's charity care policy on this Department of Health website. And charity care really is for appropriate based medical services, which is a hugely broad definition right there on the slide. It's essentially free coverage for appropriate hospital-based medical services, now provided by hospitals, including psychiatric hospitals. There are some carve-outs when you go to a hospital. You might, if you go into a hospital, incident to that visit, you might get a physician bill, a radiology bill, a lab bill. Those are generally carve-outs to this, the charity care laws. But no matter what I tell folks is you don't need to know what's charity care, what's financial assistance. If you get a medical bill from a provider, call the provider and ask for charity care or financial assistance. Don't worry, but call right away, because the non-charity care providers, the attorney physician billing company, the radiology, the lab company, if they have a financial assistance program at all, it's usually time limited. So charity care, you can apply at any time, even after a judgment is entered. It's a little more difficult at that time, but you're still entitled to get charity care if you qualify, but not so with the carve-outs. But the hospital bill is generally the biggest bill there is. So, I mean, I'm routinely helping folks get relief from bills that can be $10, $20, $40, $80,000 from a hospital bill, using this wonderful, wonderful charity care law.
Julia,
the floor. Oh yeah, sorry
to interrupt, but there's a couple of questions.
Great.
So just to confirm, you're saying that even after it's gone to collections, you can still use charity care?
Absolutely, and we'll get to that, but it's
okay.
At any time are the three most powerful words in the entire statute. At any time the hospital becomes aware that you're low income, they must allow you to apply and get access to charity care if you're eligible. So the floor, the bare minimum of eligibility is free care if your income, your household income, is below 100% of the federal poverty level. There's the bare minimum discount required between 101% of federal poverty level and 200% of poverty level. That's the window within which they have to provide a discount, not 100%, but a discount. And the good news is, at least in the Puget Sound region, many hospitals now go up to free care, 100% charity care coverage, up to a household income of 300% of the poverty level. Like I said, for a family of four, that's like $79,500. It's more than you think. Assets cannot be considered if the household income is at or below 100% of the poverty level. So apply, and we're going to talk about the application process in the next slide.
Okay, and Rita has her hand up.
Okay, sorry.
Hi, Julia. I'm just kind of, this is definitely one of the things that we get questions about that I really struggled to answer. And I think I'm interested in that carve out you were talking about too. So is what you're saying that people have to ask the doctor's office or their billing office correctly, and that that's a time frame limited ask?
If they have, so charity care is a requirement. Hospitals must provide charity care to people who are eligible. That's charity care. So any financial assistance, so entities not covered, non-hospital entities that also bill people incident to a visit to a hospital don't have the same requirement. Many have a particularly the physician group, some of them have financial assistance plans, but they might be, only for 6 months, or, so too late to apply. Whereas charity care is at any time for the non-hospital entities. If they have a financial assistance program, which they're not required to have, it might be very time limited. So, folks come into our debt clinic getting sued on debt that's 5 years old. It's not too late to apply. It's gone to collections. It's got, lawsuits been filed against them. No problem. It is not too late to apply. Again, and in certain circumstances after judgment, not too late to apply. But it may be to a non-hospital entity, and I'm going to explain, I'm often putting a cover letter when I'm helping a client do a charity care application, and I'm saying, it applies to this bill and any other outstanding debts. Here's the family circumstances. I'm throwing in the compelling facts if a client allows me. I will cut and paste that same letter to the non-hospital provider. My strategy is apply for charity care first, get the charity care determination from the hospitals, and then send that to the non-hospital providers, asking them to follow the hospital's determination of charity care. Hey, physician group, the hospital recognizes my client's low income. They have waived the bill. Here's the letter. Will you agree to abide by it? Some of them will, some of them won't, but increasingly more do. But I will take that same cover letter saying here, if they say, sorry, our program is, expired 6 months after the service, we're now 5 years later, too late. I'll say, they never had any idea. They didn't know this bill existed. They moved, they have 3 kids with disabilities and work full time. I'll explain what's going on in my client's life. Anything compelling I can use to say, here's why they didn't know about your 6-month window. No one knows about charity care. So it's sort of an easy thing to describe. They had no idea this existed. There are no notice requirements for non-hospital entities to tell people about their financial assistance program. I mean, if they have one, it's usually on the website, but there's a lot going on in my client's life, and I can explain that. They are limited English proficient, working 2 full-time jobs, 3 kids, So again, happy to strategize with folks, with you all, and or your clients on how to make that ask, and send you sample letters of what I've used. But increasingly, I find they're following suit, and I don't have the clients worry about, is it a hospital or non-hospital only? Just, you get a bill from a provider and you can't pay it, call and ask about financial assistance right away. So.
Great, thank you.
Yeah. And the next slide, please. So the hospital, if someone applies for charity care, the hospital has a right to find out if there's someone else who can pay that bill. Does the patient have private insurance, Medicaid, Medicare? The good news is charity care covers uninsured people and underinsured people, whether it's copays, deductibles, amounts outside of coverage limits, outpatient. It covers a lot. So just because you have insurance doesn't mean you're not eligible for charity care, because as we all probably see our clients, their insurance plans that have really high deductibles, or they're parts of that big medical bill you can't pay. That's why they'll first see if there's someone who can pay, and then apply charity care as if you're eligible. In the next slide, please. There's a really affirmative duty in the charity care laws for hospitals to seek out, screen, and help people apply for charity care. Unfortunately, this doesn't happen enough. So we still see people getting socked with medical debt and sued for medical debt, but they have to, the sponsorship status for charity care has to precede collection efforts. So any collection activity has to stop when someone applies for charity care. And anyone with family income 100% or below shall be deemed charity care patients. Again, many hospitals go above this bare minimum threshold. There are geographic differentials. I find east of the mountains, more hospitals stick to that 100% charity care level, the minimum required. We'd like, we hope that changes, that all hospitals are required to meet a certain higher threshold. Oregon just went up to 400% for discounts, and I believe 200 or 300% for full coverage. So we'll see. All right, next slide, please.
Julia, another question.
Yeah.
Is there a letter template about requesting charity care in one of the documents?
Yeah, it's going to be on the next slide, I believe, or a subsequent slide. So you get a bill or you get a notice from a debt collector. The patient or debtor has to complete the application. I get them now almost always on the hospital website, but should be available at the hospital, or the hospital business office can mail it to you within 14 days. If you ask for it from the hospital, there's a 14-day clock that starts, which is why I kind of like to download it off the website and send it to my client, because there's no sort of 14-day window there to apply. And if someone takes longer, if they ask for it from the hospital and it gets mailed to them and they need more time, it's okay to ask the hospital for more time. Again, that low barrier to access. I need help. I need, more time. I'm having trouble tracking down this information. Just let the hospital know. So there'll be an application and a requirement to attach documentation if you have it. So pay stubs, tax returns. So if someone comes in and the debt's 5 years old, who keeps W-2s from 5 years ago, or pay stubs from 5 years ago? One great source of information on income several years ago is the IRS website, which has these tax return summaries, which I've submitted to say, here's proof of the client's income in 2017. It was, $20,000 a year. So if the person has no documentation, they can write on a paper what their income is. That should be sufficient. Low barrier. The hospitals generally ask for more information than is needed, and depending on the case and situation, I'll provide it. I want to get that debt gone, but again, happy to consult with you or your clients about this process. Collection proceedings are stayed or stopped while an application is pending. All right, next slide, please.
Another question, Julia.
Yeah.
What if someone has already paid a collection agency for some of the funds? Are they able to get some of that back?
You're entitled to get all of it back. Apply for charity care, and there's a requirement in the statute to return your money within 30 days. So apply. You can apply at any time. So even at, and we still have clients that are told by hospitals, it's too late to apply. It's gone to collections. It's gone legal. Never too late to apply. And if it's a post-judgment case, call me. We can talk about it. It's a little bit harder, but you still have a right to apply at any time and get any money back if you were wrongfully garnished on a debt you never owed because you didn't know about charity care. Just a really important right. If the hospital denies charity care, there's a 30-day window to appeal. You'll get a notice saying it's denied for this reason. You have 30 days to appeal that. Really important to get help within that time frame before that appeal time is run, because it's done after that 30 days is up. All right.
I've got another question.
Yeah.
If time has passed since you were in the hospital and you're providing documentation, are you providing documentation for the current financial situation or the financial situation that you were experiencing when you were in the hospital? If it was like maybe a year or two ago, it might be different.
That's a great question. So most hospital applications ask for current income information. If your income has changed, you could submit income for the time of service. So do both. You know, they really are going to want to know what your current income is, but in general, it's income at the time of service that should govern. But it's a little bit part art, part science, and happy to strategize with folks on that as well. And I think the next slide can get us into some more details. So really great info in, if someone's being sued, how to stop a lawsuit, assert that defense of charity care. It's an affirmative defense, which means it's a really powerful right that can stop a lawsuit for debt that should be subject to charity care. We have a sort of checklist answer in the how do I answer a lawsuit for debt collection. In that next publication, can I get charity care benefits to pay for my hospital bill? There are sample letters to send to a debt collector, to send to an opposing attorney if a lawsuit is filed saying, I'm charity care eligible, I'm applying. Do not file a charity care application with the court, and do not give the charity care application to the debt collection attorney or the debt collector. All they need to know is that you've submitted it to suspend the lawsuit or collection activity. Great, next slide, please. So really important to apply for charity care as soon as possible. You want to bird dog that application. Keep a copy, keep a copy, keep a copy. I can't say that enough. Copy of the application that you submit with the attached proof of whatever income or benefits you've got. Lots of charity care applications get lost. Some hospitals more than others. Just keep a copy. So important. And if you don't hear, it's been 3 weeks. They generally have 14 days to get back to you, but sometimes it takes a little longer, but you can call and say, just want to make sure you got my application. You could mail it in, certified mail. That gives you proof back that the hospital got it. You can deliver it and get a handwritten note of whoever you hand it to that it got delivered, but really bird dog that application. The other trouble people can run into is if the hospital calls and says, we need some additional info. We need you to provide this or that. If you don't respond to that request, and again, this would be a great time to reach out to Northwest Justice Project or an advocate. They can, if you don't respond quickly, they can not give you charity care and say you weren't cooperative with the process. So it's really important. I mean, I tell my clients, it's important to check your mail. It doesn't bring a lot of happy news, but really important to check your mail every day, because your rights go out the door if you don't know what's going on. Check your mail, check your voicemail, check your email daily, respond to information requests from the hospital as soon as possible. Which leads to some of those troubleshooting problems. If they're asking for too much information, or we lost your application, or someone needs language assistance, or has a disability, needs help from the hospital, they have to provide it. This law requires them to provide assistance or more time if necessary. And Jennifer, or the person that asked the question, the income at the time of service versus current income. Provide what's going to be the most helpful. Of course, it's got to be truthful, needless to say. But if your income at the time of service was lower, and you're more likely to qualify, provide income at the time of service. But you're going to need to fill out that information fully, and most charity care applications ask for current income. So you're going to have to provide current income as well, and proof of income. For folks like farm workers who have seasonal income, really important. You might have a lot of money, or more income in a 3-month period, which if you just show that picture might not make you eligible for charity care. And charity care, by the way, is for people who have immigration status and for people that don't. So really important to provide your annual income if you can, not just the seasonal income, if the source of income is a seasonal income source. Once charity care is approved, that lawsuit should be dismissed. And actually, that's a process that should be bird dogged as well. You want to make sure that lawsuit is dismissed, and you can check back an email with the attorney. Email is the best way because you have a record. I like that as a form of communication. Many more of my clients have email now than 5 or 10 years ago. But you want to ask that attorney, has the lawsuit been dismissed? You can call the clerk's office, the court clerk, and find out as well. Next slide, please. So when there's, we've sort of covered this, but if there's, you know, when you go to a hospital, you're probably going to get several bills, one from the hospital and several from non-hospital providers. As I said, I have folks apply for charity care right away and then wave around the charity care determination letter. I also make sure, another tip I want to pass on is, you know, when they apply for charity care, either on the application or in a cover letter, that they or you write, ask for charity care for this service date and any other service dates, period. You know, this date plus any service date, you know, in the past. And then waive that determination letter, send it to the other providers, asking them to follow the charity care determination. As I mentioned, they may have a deadline that's passed long ago. Good time to say, here's what my client, here's what the patient has been dealing with. You know, please suspend your rule about a 6-month application and accept their application now. They had no idea that there was even a financial assistance program at all. You know, here's what they've been dealing with. Next slide, please. So even after judgment, even after someone's been garnished, there is this right to apply and be refunded. You're going to need to vacate often, you know, you may need to vacate the judgment before applying for charity care. So it can be a little bit trickier, but we've done it. It can happen, and happy to be called by you guys, your clients, for a post-judgment charity care application. Next slide, please. Some emerging issues. Debt buyers are a type of debt collector. They really are investors that buy older debt for pennies on the dollar on the secondary market. They've paid very little for the debt. So pretty much, you know, they sue like crazy, and anything they get is gravy because they've paid so little. They're not the original creditor. They're just an investor looking for opportunities to sue people and get money out of them, as terrible as that sounds. But they're an increasingly bigger part of the debt collection industry. They have some special rules that they must follow when they bring lawsuits against folks. We've been very successful. This law went into effect June of 2020. The legislature said, you know, people have no idea when they get contacted by, you know, LVNV funding. No one has ever had a relationship with LVNV funding. You know, people are confused by what it is. They don't know what the original debt is. It requires the debt buyer to make certain disclosures that they've paid less than the face value of the debt, and attach information to the complaint that they're served with at the beginning of a lawsuit, that the debtor is served with, so they can understand who's suing them. So some really powerful rights. That is in our publications as well, these new rights, but we're having good success at challenging debt buyer lawsuits on all kinds of debt collection areas because they're not complying with these new rules in the Collection Agency Act designed to provide people more information. Patients who have Medicaid coverage, you know, is really hard to bill, let alone sue and collect on someone with Medicaid. It's really not okay. You know, reach out to me right away. They're very easy to turn around. It's just, unless in certain circumstances, it's just extremely difficult to bill, let alone sue and collect on someone on Medicaid, because they shouldn't be even billed in many instances. So we have this publication, Billing and Medicaid Apple Health, which has sample letters in it saying, I'm on Medicaid, please, you know, stop this collection action. We talked about no more bench warrants related to medical debt. The requirements for notice for hospitals and debt collectors to provide more notice to people about charity care have increased in recent years. You have a right to an itemization on medical debt. What's it for? What interest has been applied? What credits and insurance payments have been applied? Again, this is all in our publication. No more surprise billing for emergency care, where you go into an ER and you get billed out of network. That's no longer legal in Washington state. And next slide, please.
Julia, just to let you know, we have about 10 minutes
Yeah.
left.
Okay. This is a slide for COVID resources for testing, vaccination, and treatment. All I'll say is, you know, testing, vaccination, treatment are free for low-income uninsured Washingtonians, regardless of immigration status. Northwest Health Law Advocates, Columbia Legal Services, and this NJP brochure have, and particularly the NOLA website and the Columbia Legal Services, have fantastic resources and Q&A and information about COVID-19 treatment and coverage in there, even if you are insured, and links to the different insurers. Can't tell you how, like, just such fabulous websites for folks, particularly for undocumented folks. Next slide, please. So these are legal resources and info, not just for charity care, but this is how to reach our debt collection defense clinic, which we run every Tuesday, our remote clinic. You don't have to be available on Tuesday. You can call us at any time if you're low income in King County. Outside of King County, our statewide clear intake line is the number to call. You can apply online for help too. Washington Law Help is the fabulous website I've been talking about, a co-production of many organizations. Information is on there. Northwest Consumer Law Center helps folks between 200 and 500% of FPL, people who are also low income, but maybe not low income enough to qualify for our services. Really terrific consumer law center that does foreclosure work, bankruptcies, debt defense, auto fraud cases. A really great resource. Next slide, please. King County Bar Association's Debt and Bankruptcy Clinic is another resource. They don't have any income or citizenship requirements for them. They can, and it's also a remote debt clinic. It's staffed by bankruptcy attorneys. You don't have to be declaring bankruptcy to get help from them, but it's staffed essentially by people that know a lot about debt, just like the folks that staff our debt clinic. Again, those also just relisted those resources from Northwest Health Law Advocates and Columbia Legal Services. Next slide, please. So student loans. My first stop, last stop, anytime stop is the National Consumer Law Center's website on student loans, studentloanborrowerassistance.org. I hand that website out like candy to friends, family, clients. It's really great. It's the A to Z, what loans to get or avoid, repayment and discharge options if you become disabled, if you lose your job, updates on for-profit school litigations and for loan forgiveness, regulatory changes, click-throughs to the Department of Ed forms, applications, and information on that site is available in many languages. It's really terrific. It's very comprehensive. And in general, you know, federal loans are the better loans to get. They have flexible repayment options. They have discharge and cancellation features. There is no statute of limitations on a federal loan. That's the big drawback. And the federal government has vast collection powers if you default on a federal loan. But there's so many good options and a repayment, flexible repayment options, income sensitive repayment options, and discharge, and more coming online pretty routinely. They're just the better and generally lower interest. Private loans, though they do have a statute of limitations of 6 years, they generally don't have flexible repayment options or discharge or cancellation options because they don't have to. When Congress gave them in 2005 bankruptcy reform, gave them the gift of non-dischargeability in bankruptcy, unlike federal loans, which have these repayment options, the private lenders were not made to also offer them. So for now, private loans and federal loans, it's really hard to discharge federal and private student loans in bankruptcy. Who knows if that could change, but consumer advocates have wanted that for a long time, since this bankruptcy reform bill. Anyway, just a terrific website. I tell people, sit down with a cup of tea or coffee and just work your way through it. There's a lot of information on there, but really, really terrific, even if it is the longest website name on the planet. We have a Washington student loan advocate brought to us by a student loan bill of rights that passed in Washington a few years ago. Stephanie San Pedro is Washington's student loan advocate. She's terrific. I've done outreach events with her. Her office receives complaints from student loan borrowers in any number of areas. More information about that office and what they can do is at that link. The Washington Attorney General has a site for student loan resources and filing complaints also with its office, and they coordinate with the Student Loan Advocate's office as well. Happy to report the Federal Consumer Financial Protection Bureau is back actually protecting consumers. Yay. They took a little bit of a hiatus, and the new administration, it got started in 2011. And it was fiercely protecting consumers, took a 4-year hiatus, getting back up to speed with the new administration, but a really terrific resource to file complaints. And they're back to protecting consumers and staffing up again in any number of areas: student loans, mortgages, landlord-tenant debt, credit, repair, debt collection. They maintain very good contact with legal aid attorneys and advocacy centers around the country to get a read on what's going on and how they can help consumers. And the U.S. Department of Education website is obviously a great resource for the latest and greatest on student loans. I like the National Consumer Law Center site because it's written from a consumer advocacy standpoint. It gives you some side-by-side comparisons of options, sort of opinion you won't get at the Department of Ed website. So, and they have click-throughs at the NCLC site to the Department of Ed forms and information. Next slide. And is Angela Anderson still on this call? American Financial Solutions has a fabulous student loan counseling program. There's how to get in touch with it online or by phone. I've referred clients there and worked with their credit counselor, that Donna Loitz, who's terrific. And it's just a really wonderful resource for folks to help get information on their federal loans, private loans, and get some counseling on repayment options and discharges. So, a terrific resource. Any questions? All right, sorry to chat your ears off. I'm very passionate about these topics, And again, would love to be contacted by any of you if you want to strategize on a debt issue, or your clients has a lawsuit or debt collection issue. And I can be a conduit to any other services Northwest Justice Project offers as well. Or, outside of our agency, happy to connect people to the right resource.
So Julia, I have a question.
Yeah.
Always. Anyone who's met me knows that I always have the questions. Can you talk a little bit about how to help clients navigate which debts to pay first? Like if folks are dealing with debts on multiple fronts, how do you make decisions about where to start?
We do have a pub on how to prioritizing debt. It can be different depending on the person, but in general, and the lens I see it through is, debt collectors have really good ways of making people feel bad and guilty and harass them into paying a debt that's a low priority debt, but making it a high priority because they're stressing you out about not paying it. Housing, food, utilities, those are, really the top needs. So, lots of clients feel terribly. I wish I could pay this bill, this 4-year-old credit card bill to my bank, or, another bank or a store credit card. And, they're on Social Security or SSDI. And I say, there's a reason we exempt this money from debt collection, is because you have other priorities to pay. This entity is going to be okay without your money. You need your $775 a month to pay rent, buy food, get heat and lights. So, generally housing, food, utilities, transportation are in most people's top 4 from our perspective, but it can depend. But what we see all too often is these old debts that are, being pressured by debt collectors on old debts that are not a priority, and making themselves a priority when they shouldn't be. And that's where we like to help folks, file that declaration of exempt income and assets saying, I've got nothing to take, so please stop trying. Even if they get a judgment, they can't take it. And if they take exempt money, it's going to violate state or federal law. So particularly after they're on notice.
Great, thank you. I'm going to drop a survey link in the chat so folks can start working on it, but we have another question. So Ryan, go ahead.
Thanks, Julia. I'm looking forward to getting the slides, because I'm going to tear through this again for 1 or 2 of my clients. A big intersection that I'm seeing right now is between medical debt and divorce. And I know that Washington is a common debt state, so the person I'm working with is on the hook for the debt of her now ex-husband. And I'm wondering, there's a court decision that says that the debt is to be paid by the partner. Is there any teeth that we could use to move forward and get the debt collection company to leave someone alone that is not supposed to pay?
You can send them the court order that says that, but that debt collector is going to see that it's a community debt and go after whoever can pay. I mean, I have, I work with really smart family law attorneys that deal with this a lot and would be a great resource on this issue for tips and tricks. But it's a tough situation. Frequently the remedy is pay or go bankrupt and then seek, compensation from your ex-spouse who was actually the one that should have paid. But that's hard too. And particularly if the other spouse is low income, it's sort of, it's tough. It's really hard. The creditors sort of generally don't care about the family law court orders. And, but there are tips and tricks, and I'd be happy to connect you with an advocate at NJP who could help walk through what you can do. And
Yes, please.
yeah, okay.
Yeah, the collection agency doesn't care.
Yeah. And you sent them the court order?
The person I'm working with had already sent them the court order before they came to me. So they were informed that the collection agency didn't care.
Yeah. So yeah, you have a right to collect from the person who should have paid it, but that's, as I said, often not really a, you know, a viable avenue if the other person's low income.
So Julia, there's also a request for your contact information in the chat, if you don't mind adding it.
Not at all.
Folks would love that. So here, I already put the survey in the chat. If you could fill out the survey, it's very, very helpful. I am planning out workshops for 2022 right now. So your feedback is really helpful in thinking about what else you all would like me to plan for next year. So take a couple minutes and fill that out, and you can listen in while I share a couple of updates. We have one more event this year in December. We have our Bank on Washington Coffee Hour, and it will be a community conversation. So we're going to be talking about how do we welcome folks that are unbanked or underbanked into financial institutions. And while we definitely want financial institutions to be at the table and part of that conversation, I also would like all of you to be at the table and part of that conversation, because you are the folks that are working in communities that are struggling to access banking services. So please join us. Also be camera ready that day, because it will not be a presentation, it will be a conversation. So the link is there, and I will put it in the chat if I can manage to talk and do that at the same time. The next thing too is so excited. The network is on LinkedIn. We just got on last week. So join us in our LinkedIn. Yes, hooray for 2021, and we're finally on LinkedIn. Whoop, whoop. And then also, did you know that we have 2 Facebook accounts? We have a Bank on Washington Facebook account, as well as a general Financial Empowerment Network Facebook account. So join the conversation there. There's really interesting posts. We post all kinds of things, announcements, updates, resources, all kinds of stuff. So join us on the interwebs. And that's all I have. Any final questions for Julia or thoughts about the world of debt collection and garnishments?
And again, happy to consult whenever. All these topics I'm passionate about, and others. There's lots we didn't cover, so reach out, please.
In the survey link, one of the questions is, what would you like to hear more about next year? And it's all different sorts of debt related questions. So please fill it out and let us know, and we will get Julia on the calendar for our next events. And also, just so you know, I see Tammy is requesting to be added to our email list, and I will add everyone who attends these events. I add to the email list, and I promise not to spam. You'll just get a couple a month from me. So, all right. Well, thank you all so much. Thank you so much, Julia, for this information. It's always shocking and enlightening and enraging all at the same time. So thank you for the work you do with these shady collection practices and advocating for folks' legal rights. So, and what everyone deserves.
Thank you for the work you guys do, and yeah, please reach out.
Great, thank you everyone. Have a wonderful afternoon.